Yeah.
I was in trial for 2 days. My law clerk has given notice and was done yesterday. My other
God.
legal, my other legal assistant is out vomiting. So
Okay.
support staff in the office for 3 times.
Yeah. Well, we had to adjourn one motion because one of the attorneys was running 103.5 fever yesterday. So,
Oh, I wonder if something's going around.
well, two people were at somebody's office on Monday acquired COVID.
Oh, no.
So, oh yeah, it's back. So, all the
Okay.
fun, all the fun of that all happening. Welcome,
Mhm.
Miss Hanson. Can you hear me?
Yes, I can. Good morning.
Mr. Hess, how are you doing this morning?
Good, good. How are you?
Hey, it's going to be a morning. It's always, I just realized I was pacing for 20 minutes. I generally pace when I think, and I was pacing for 20 minutes before this. I'm like, I have done over 450 motion days. You would think I would get over the nervousness.
Yeah,
It's
yeah.
okay.
Always
I
there a
still
little
get
bit, I
nervous
guess.
in front
Sure.
of noise, so it's good.
Yeah, well, I think none of us really absolutely know what's going to happen. I have a better idea than most, but that doesn't mean that's going to be the bottom line answer. I've had things go sideways 2 minutes into a motion. So, in any event, let's go ahead and go on the record in the matter of Hanson versus Hanson. I've read your motion, Mr. Hess. You still haven't received the responses?
No, I haven't. Nope.
Okay. Ms. Campfield, what's going on?
What I can
I
tell,
realize this week you have a couple of days that you were out and you have a missing clerk, but these
yeah,
were due a couple weeks ago. Well,
correct.
more than a couple weeks ago.
Well, I have been communicating with Mr. Hess in that regard, as has my office. My client turned over to me a very large portion in time, I might add, of
Mhm.
medical records that we needed to go through for verification of the disability that will be alleged for spousal support.
Okay.
Um, we were waiting on the written answers to the actual interrogatory questions. She did provide those to us. My staff unfortunately misplaced those. We have looked everywhere that we could possibly
Okay.
do.
All right.
It was not
I'll do what I generally do in this,
well,
starting.
if I may, I have a
Yeah.
little more.
Yeah.
We did this week on the 27th send Mr. Hess a proposed stipulated protective order that those
Okay.
medical records would be provided without them being copied, disseminated, the usual.
Yeah, that's fine.
To my knowledge, I haven't received that back the 2 days I was in trial, but
Yeah.
Mr. Hess would know
Mr.
better.
Hess,
No,
Mr. Hess, did you have any problem with that?
yeah, I do. I do have a problem with the proposed stipulation. It was very overbroad. It prohibits me from providing any discovery to my client. I mean, it was just it was way overbroad. I mean, I can't
Okay.
give any of these answers to my client. I'm not going to sign that. I will say that
Well, you have to discuss them with your client. That's for darn sure.
I will
But
say also that I did grant a 2 week extension in July, and they would have been due July 24. No objection was filed to my
okay.
discovery
All right.
request. I mean, any objections are waived at this point. I mean, there's been no motion.
Well, what I will do is I will give the protective order to the extent that only you and your client may have copies of this. His client gets them. Medical is on the issue, therefore his client has to know what he's fighting and what he's
And
arguing for or against.
here's my problem with that. In a criminal matter, as well as a civil matter, these would not be given to a defendant. They would not be given to a client.
This is a family law matter, and they
But,
will
and I
be
understand
because he
that.
has the right. And what I will do is issue the protective order that he's not allowed. Neither the attorney and the client will keep it privileged between themselves. They will not publish it to anyone else, and they will not discuss it with anyone else.
Thank
And
you.
you will get these answers to Mr. Hess's office by next Thursday, or it's a $25 per day charge starting next Thursday.
Thank you.
It's not to be published. It's not to be put on any media. It is not to be discussed with anyone else but the attorney and his client.
Okay.
I will protect her to that extent, but to the extent that this needs to be discussed with Mr. Hess's client, he needs to know what they're facing, and the client needs to fully understand what the argument is. So he is allowed those copies.
Thank you.
All righty?
Yes, thank you.
All right.
That way we get you your answers soon, Mr. Hess, and if not, there's some charges to be piled up. All righty.
Thank you, Your Honor. I guess I'll just note I do have 4 motions this morning, one more with you. I don't know what you had on your agenda.
Well, Miss Campfield's got one too, but the opposing attorney on Miss Campfield's is going to be late.
Durham is my other one with you. So if there's a way
let me see if they are available.
I'll just hang out.
Well, hang out. Yeah, we'll let you know as soon as they're here, because otherwise, yeah, I do keep you on here until we're done with you.
Yep. May Miss
Um,
Hanson be excused?
Oh, of course, Ms. Hanson, it was
And-
nice meeting you. Good luck with your disability claims. Those are never easy.
Thank you. No, it's not easy.
No, it's never easy. And what it takes is the average less than 2 years now? It was averaging 2 years to get it, and you generally got denied, and then the 2 years included the appeal period.
I was accepted within 3 months.
Oh, very well. Okay.
And I didn't have any lawyer or anything like that. I just filled in the paperwork.
Well, then
And
then the stars have aligned for you. I would let you
Thank
know
you.
that normally it takes 2 years.
I realize that, yes.
Congratulations, Mr. Hess. You'll have an interesting time reading that one.
Okay, all right.
Because
Thank you.
if it was good enough to get her in 3 months, I mean, there's some, yeah. Good luck,
Ken,
everyone.
I will call you later today, okay, Ken?
Yeah, get
Thank
those
you.
done. All righty, take
Yeah.
care, everybody.
Yes, I will.
All
right.
Bye-bye.
get
Dan,
this
stick
modified.
around. Angelique, we'll put you in the waiting room, and
Thank
if you
you.
have other motions, we'll get you in as soon as possible. Do we
Dan?
have
I didn't have you for Durham. Who do you represent?
I represent
the mother.
Stacy Durham.
Got it.
Oh, I apologize. I figured you had him because it's a nice lengthy response.
Oh, yeah.
Well, actually, he amended
Her
the actual
motion.
motion. Yeah. Do we have both
Correct.
parties here?
No, I don't have defendant yet, but I have a few phone numbers I need to identify.
Let's identify the phone numbers. Dan, you want to stick around to identify phone numbers? It's
I
fun.
can. I have another one.
Okay,
with-
you go. We'll bring you back in when we get here. We got to give him a chance to get here. I wasn't expecting him to, after reading your amendment to the motion, I wasn't expecting him to show with
I
what's
see.
in what's with the
Okay, so
content
I
that
have
you
a
put in there.
Zoom hearing with Judge McNabb, and
Okay.
then so
No
I'm
problem.
going to try
Just
to
come back when you can.
And I have an in-person later this morning with Judge West. So fun.
We'll try and get you done before you have to be in for your in person.
All right.
All
Thank
righty.
you.
Thank you.
Yep.
All righty.
Okay,
Let's identify phones.
sure.
Guess who the first phone number is we picked in?
Okay.
Samuel.
Okay. Great.
He is here. So cool. We are here in the matter of Durham versus Durham. Miss Durham, you filed a motion on your own, but your attorney has supplemented it with some information. I've read it. Is there anything you'd like to add to it, Mr. Hess? I noted you added the articles from Wood TV and the other issues in this matter. So there is.
Yeah, I don't have a lot of new information. I checked to see there was a probable cause hearing in court earlier this week, and I couldn't find out any information online. So my office.
Let's ask the person that was involved. Mr. Durham, what happened this week with your probable cause hearing?
They offered me a plea deal. However, my attorney and we are going to go to circuit court with it due to our evidence and everything that we have.
Okay, but so far, I think we have confirmation you had your child with you, and you fled the police with him in the car. Correct?
That is accurate.
Yeah, that's accurate. I was going to try and not get into all the allegations against you. I mean, they have hit the media. I was not aware of that, but that was attached as a proffer, an offer of proof to say that these are more than just allegations. These are actual documented, and you are being charged with, I believe, several issues. Correct? What are the current charges?
That is accurate.
Yeah. What are the current charges, sir?
I don't know them off the top of my head. I left my court paperwork back at the house, unfortunately.
Okay.
The paperwork.
But they.
Yeah. Yes, sir.
But they are. Go ahead.
Well,
other attorney.
Yeah. Bottom line, folks. You endangered this child. That is going to suspend your parenting time until further order. So what we'll do is I'm going to suspend your parenting time until further order, and we'll find out what happens with these criminal charges. You're facing some big ones.
Can I please ask a question
Of course.
in regards to this? I know that you're going to suspend it.
Well, I mean, you've given me very little choice. You endangered the child. You took the child on a event that has had you charged with
serious allegations. That is accurate.
Very serious allegations.
And I'm not refuting that. I'll take.
Well, don't say too much here. What you say I know, but what you say can and will be used against you because the prosecutor can get a copy of this. That's why I'm not trying to
Okay.
go into the charges.
All
They're
I'm trying to
awful.
say is I'm a loving father. I made a mistake as a human in regards to certain actions that happened, but I'm not the only one in this party that has put him in danger and everything as well. Every time my ex-wife was going through her situations, I
Well,
always bailed them out because I love my son to death. Like,
well, and that's why I'm suspending it until further order. We will be talking in the future once we figure out what's going on with you and whether you're even going to be available before that child turns 18.
yes, sir.
So,
Because I'm not sure if you're not going to be heading for a longer term. So he's 13 now. And if I remember the sentencing guidelines for what they are charging you with, it's a possibility we won't be talking about parenting time at all until further order.
Correct, but the evidence that my attorney is getting and everything,
Well, and
I
you
know
have
it'll.
you have that right. That's why I'm reserving the right for you to come back, after we figure out what's settling up with all these issues.
Is there any way when? Because I know right now, court ordered, I'm not allowed to speak to him and everything.
Well, yeah,
I've
well, that was going to be my other question. There's a protective order against him in the criminal case as well because he was involved as a
correct,
victim.
but what I'm trying to ask you, I'm assuming you're the judge, correct?
Yes, sir. I'm the court referee that's assigned to this matter. Yes,
Okay.
I'm pretty much the equivalency. Yes.
Okay,
Okay.
sir. So
Once if that order ever gets lifted, you may come back to court and see if there's any possibility of doing supervised parenting time. But I'm not overriding the criminal court. I kind of figured there was a no contact order in that case, simply
correct, and
because
that's
of the
why I was asking
circumstances.
if they lifted that.
If they lift it, we can you may file a motion and we may discuss it. I don't know whether that will be appropriate or not either because I think that the 13-year-old is going to have some input here. You scared him.
I do. I don't disagree that he probably feels unsafe and he's scared. I agree to
You
that.
took off and led a police chase with him in the back seat.
I panicked
Oh
because
yeah, I know
didn't.
you panicked because what you were there to do.
It wasn't what I was there to do. You are going off of allegations based off the limited stuff that the media and that everybody put out there, other than the factual facts that
Okay.
that
In
weren't
any
put out
event,
there.
you fled the police with the 13-year-old. That's why I started with that, and that's what I was going to base. You endangered the child, and understanding the other charges that were against you, I figured there was a no contact order. So that's why I'm suspending your time because I don't have a choice, and we can
Sir,
discuss it in the future.
Your
I
Honor,
try to get updates through other individuals, and
Right.
my ex doesn't update them. She blocked everybody. I'm going insane here, not knowing anything how he's doing. It's killing me, sir, and it's.
Well, that's going to be the criminal court. They want no contact with that child or anything.
Yeah,
That's
but
not
I'm
her.
not the one reaching out. I'm third parties are
If
trying
anyone
to
reach
inquire.
if anyone reaches out on your behalf, it's you. That's considered you. Be very careful what you're doing. If that chain of events leads back to you, that still could be a violation of your order if they're doing it on your behalf because they're acting in your age as your agent.
All right, I'm sorry.
Take,
sir, I didn't
no,
know.
I don't get yourself in more trouble than you're already in. You're already in enough. You're in the hole. Put the shovel down. Stop digging. You're deep enough. Okay.
All right.
But at this point in time, we'll end this discussion before we get more involved in things that you don't want to really have on air.
Yes,
But I
sir.
will suspend the parenting time. Mr. Hess, I'll sign that order as soon as
okay,
possible.
and I guess the balance of my motion concerning change of custody is
I was going to ask, how did you want to do that? Did you want to adjourn until we find out what's going to happen here? Because technically she's got temporary legal custody because there's no contact. So
so I can put that in the order temporary.
yeah, put temporary legal custody in there because she can't contact him to get any information or to get input because she's not going to be allowed to because of the underlying criminal case. So I hate to do that on a Friday morning, but I think I don't have a choice because she's got to make decisions for this child and she can't be tied to him, but it's temporary. I'm willing to bring that back depending upon the outcome of the underlying events. So everything is reserved.
All right, and then she has, yeah, obviously extended parenting time.
Correct. Well, I just suspended his, so technically that gives her all of it. And again, I can't override the criminal order. That's even more stringent than my orders.
All right, and then just I guess the further custody proceedings are adjourned, or
Yeah, adjourned until further, because we need to find out what's happening. This could be a temporary thing. This could be, like I said, with what he's facing, we may not, why don't we do a settlement conference in about 3 months and see where this is vetting out at?
Okay, all right, okay.
That way we know when a trial date is, what the likelihood is, and Mr. Durham, what you'll have more information about what's going on, so we don't let it slip, because eventually if you do go away till the child's 18, I will more than likely have a hearing, which will more than likely grant her actual final or modified legal and physical custody because you won't be available. All right. But we'll see. I'm willing to leave it open until we see what happens and how this vets out.
Okay.
All righty.
Thank you, Your Honor.
Good luck, everybody. Mr. Durham,
Thank
take
you.
care. Good luck with the child. Mr. Durham, good luck with your case.
Yep.
All righty. Good morning, everyone.
Good morning.
Good morning.
All right. So Ms. Ross, can you hear me? Jessica, can you hear me? Because Ms. Camfield, you can hear me. Ms. Smith, can you hear me?
Yes.
Okay. Two that aren't fully connected yet.
Are you able
There
to?
you go. Yeah, now we're here. Now we can hear you, sir. Welcome.
Good morning.
Good morning.
Good morning.
Yeah, Ms. Camfield, Mr. Hess got lucky. The first phone we brought in was the other side, so we were able to.
Oh, that's
So, and we just got done with that motion. So,
Thank you, Angelique.
good.
okay. So, Jessica, how about now? Well, that's okay. Yesterday I was in the middle of a hearing and my computer at the courthouse died. It just went black.
Oh, that's not good. Well, I guess that's
So.
one reason why Judge West has things in person.
I did have one in person yesterday as well. So, I mean, I do them. I offer it. Most people just would prefer Zoom.
Correct. Mhm.
It's just easier to come in from your living room.
That is true.
Well, once I found out there were some of the people that don't have that much money that would come in for motions in person and then not be able to leave because they couldn't get their car out of the parking lot because they couldn't afford the parking. That
Oh,
hurt. That hurt here. I'm
yeah,
like, that's just wrong.
of course, of course.
So that's the last thing we want to do is, because I mean, let's face it, it's a cattle call. So if you're there at 8:30, which you do when we're live, and you got 80 people in the courtroom, somebody's not leaving till noon.
That's correct.
At least with these, so that the parties understand. We set mine up at 8:30, 9:30, and 10:30, so that nobody's in the waiting room for hopefully longer than an hour.
Thank you.
Well, it also drives my clerk nuts when there's 80 people in the waiting room and you can't hardly tell who's who.
No, I just think that's the best way to do it. And I think that Judge McNabb tries to do that as well. And
Well,
Judge Byanek.
Yeah, our Supreme Court has asked us, especially for motions, because it is for the parties' ease.
Mhm.
It's not about us. It's about all the people that we serve. How about now, Jessica? I do have a way of doing this. Let's see if I can do this old school.
Or I can give her the call-in option, referee.
Well, I was about to call her. Let's see if she's got her phone. No. Yeah, never mind. It's her law firm. Because that's what I've done with others. It works pretty well. I can't do it at work. I can't do it at the courthouse. I can do it here at home. my computer at the
She
courthouse.
told me she doesn't want to do the call-in option. She'd rather restart her computer.
Okay, then tell her to restart the computer.
Can we move on with another case?
Yeah, let's move on with another case, folks. I'll put you all in the waiting room and I'll let her reboot.
Okay.
Kind of odd that she didn't want to do the call-in option, but okay.
Okay.
We can do Hernandez versus Young.
Alrighty.
Never mind. He disappeared on me.
Is Jessica Hernandez here?
Yes.
Shoot.
No, I know he's one of these phones, so I'm gonna identify.
Okay,
two
bring
more
in some phones. Yeah, sure.
He must have. I relabeled him. And he must have left and come back in.
No problem. Well, I think I do have. Oh, yeah, his phone number is 4.
Ms. Hernandez, this is your motion. Is there anything you care to add to it?
No.
Okay. Mr. Young, is there anything you have any questions of? I didn't receive a response.
You said what?
Is there anything you'd like to add or any questions you have? I mean, bottom line, we have a change of circumstance requisite. Okay.
You said what? You said what? I'm in the
Asking
car.
if you have any if you have any questions.
Yeah, I do have a lot of questions, but
Okay.
I want to hear what you got to say. Like what
Bottom
was you saying?
line, we have a change of circumstance to have child support reviewed. So I'm going to send it to the front of the court for a child support review.
Okay.
I mean, that's the only thing we're here for. So it's set, she's alleged that there's now daycare expenses, and that's a change of circumstances from over 2 years ago when the first order went into place. So that's a review of child support at this point in time.
So what? So my bills of what I got going on just don't matter, right?
By law, no, and neither do hers.
So I work all of these hours to pay her, right? I already give her $360 a month.
You're given $360 a month, which barely covers diapers for a kid this age. But in any
And I
event,
pay
So
12.
this is what I want you to do. This is what I want you to do, Your Honor.
Yeah.
Put in a motion for me to get my parenting time with my child. Can you do that for me?
no,
Because I haven't seen this child. I haven't seen this child in 3 years. But y'all want to keep jumping on my phone talking about money. She don't let me see my child. But y'all want to keep jumping on my phone. What?
Young, then you need to file.
You put it in. You put it in. You put it in for me. Y'all jumping on my phone, letting her file motions, want more money. You put in a motion for me.
No.
What you mean, no? You keep jumping on my phone talking about
money.
money. I got 4 other kids that need to be took care of. She got 3 other kids that need to be took care of. I got 1 that she don't let me see. And y'all keep getting on my phone talking about money. Money. Right? Well, you put in a motion for me. You said what? And I haven't seen my child in over 2.5 years.
Okay.
She don't let me see my child. She don't let me see my child. You put in a motion. You put in a motion for me. It's going to get ran through faster if you do it.
I cannot do it. You must.
But you can be on my phone talking about money that you cannot
because
take.
She filed a motion.
Right?
Otherwise, I wouldn't be here at all with you two.
It don't matter. It don't matter. You put the motion in for me.
Okay. At this point in time,
put the motion in for me.
I send it to the front of the court for child support. Have a good morning, both of you.
Yeah.
Thank you. I appreciate it.
Okie dokie. Next.
Okay. I'm gonna bring in Miss Ross, see if she connected.
Okay. How about now, Miss Ross?
Yes, I can hear you now.
Perfect. How you doing this morning?
Doing well. How are you?
Okay, other than being frustrated that you couldn't get your computer to work, right?
I know. Sorry. I had it unplugged because I thought I maybe had to appear at the courthouse. Oh, it looks like you're there anyway.
No.
Oh, no. Okay.
I prefer doing motions from home because my Wi-Fi connection is actually better at home than it is at the courthouse. And yesterday I was at the courthouse and my computer died mid-hearing.
Oh, no.
So yeah, we'll just do this.
Okay, sure.
The only problem is my wife gets upset with all the files that are all over the dining room table.
Yeah.
So, in any event, let's go ahead and go on the record of the matter of Byanek versus he. I've read all the filings, but I guess there's only one question right now that needs to be asked. There's a guardianship that was put in place, and it's a full guardianship at the end of July by Judge Fine in Ottawa County, correct?
Yes.
Yes.
And that is still in place?
Yeah.
I'm afraid this court has lost jurisdiction until this court loses jurisdiction to the probate court when the probate court has taken action. I can order anything in this case and nothing will happen. The guardianship, it takes precedence. So what has to happen is she has to go to the guardianship and either ask for it to be dissolved or start getting her parenting time through that. But I will tell you, Ms. Campfield, that is a change of circumstance. There's a big change of circumstance. He got custody and he gave custody up to a third party. So no, that issue will be reserved. Now, I have had it happen before where Judge Fine finds out that there's a custody battle happening in Kent County, and I've seen him dismiss the guardianship under certain cases to allow the custody battle to occur. So yes, there is a change of circumstance. The court will eventually grant a hearing on it because the child's been left with a third party. However, I have to reserve on that issue because for now, I don't know if Judge Fine will keep the guardianship or relinquish it, or he'll allow her to do the stint where they take about 2 years, they increase the parenting time, and then that parent eventually gets custody. But right now, the probate court has taken superior jurisdiction.
Okay.
Understood.
Yeah, unfortunately.
My understanding that there was concurrent and ancillary jurisdiction on this.
There is under certain circumstances, but the guardianship takes precedent. In other words, depending upon what they rule, I mean, if he allows her to start parenting time and start issuing to work on the issue of trying to get custody to her, because obviously Mr. Byanek has relinquished custody to, I believe, his mother, to a third party. What?
My mother and stepfather, but I'm here basically like every.
Yeah, I understand, but you have relinquished all custody to those parties. You've given up your custody under that guardianship. Granted, a parent has superior custody rights over a third party. Unfortunately, the guardianship does interfere with that. Once the guardianship is in place, the probate court has taken jurisdiction, and that's why I will reserve the issue. If I will allow either party to contact me if something has occurred in the guardianship, like he's going to relinquish it, I will allow Ms. Campfield and Ms. Ross, you may contact my office and we will set up a hearing with either me or the judge, but we'll do a settlement conference to do a status, depending upon what happens. But your filings need to be in the guardianship court at this point.
Okay, but the motion will stay filed.
I'm adjourning the motion for custody, parenting time, and child support. Yes.
Okay.
I'm adjourning it because I can't make a ruling on it. You know, it's not that I can deny. I could deny it, but there's no sense because I don't know what's going to happen with the guardianship at this point.
Okay.
So I will adjourn the motion on custody and parenting time and child support, and then you guys have to get to the probate court and find out what they're going to do. If the guardianship stays in place,
it won't. Based on the law, it will not stay in place.
That's what I don't know. I know I saw some of your arguments and it may not. That's why I'm reserving setting up a settlement conference.
There's been months and months of non-participation by the plaintiff and failures to follow orders.
I didn't say who was going to win the custody battle. I just said there's going to be one.
I just want to note for the record that this is gamemanship by the grandmother as she attempted to file a guardianship.
Well,
didn't show up and then filed it after this hearing was scheduled previously, and then her attorney got an adjournment the day of the last hearing.
And why do you think I'm reserving everything? Because the guardianship has to be dismissed before I can do anything.
Okay.
All righty. And that's why I'm reserving, and you may contact my office to set up a settlement conference and we'll discuss what's going on with the guardianship and to set up a hearing or FO front of the court intervention or whatever. But I need to know what's going on with that first. Okay. But I'm adjourning your motion on the other issues. And like I said, I said there's a change of circumstance. I didn't say who was going to win.
Okay. Thank you.
Thank you.
Good luck, everybody. Have a good morning.
Yeah.
Take care. Well, I mean, once the guardianship came into place, that just put the arrow through the whole system. There's a lot more easily ancillary jurisdiction when we have it in our own county, Ms. Ross. But when it's two different counties, I have to wait for the other county to do what they normally do.
I understand.
Yeah.
I'll just present
what I would do in our county is I'd send the custody motion up to the judge who's doing the probate work.
Well, she had filed it here, and that's why we had notified the court, and then she ended up filing it there, and then got an adjournment.
Well, it is what it is at this moment. So we'll see what happens as it vets out. Okay.
Okay. Thank you.
Good luck. Well, don't thank me yet.
All right.
It's where we're at. Okay.
Thank you.
Take care. Good luck. Thank you.
Bye-bye.
Have a good morning.
You too.
Okay.
When would you like that settlement conference?
I asked them to call because I don't know. Judge Fine might keep the guardianship, and if he keeps the guardianship, there's no need for a settlement conference.
Okay, so they'll contact me.
That's what I told them. Yeah,
Okay.
because
Sounds good.
since I don't know what's going to happen,
Sure.
it's kind of hard to, because he can keep the guardianship and it can go on. There's a 2-year plan they normally do with the parents to work parenting time, see how it goes. And if that works, they eventually turn the child back over to one of the parents. Judge
Okay.
Fine has that option. If he also has the option to dismiss it. And if he dismisses it, then we have a custody battle. And there are some interesting arguments back and forth. So like I said, I'm not making a ruling on who's going to win it. I'm just going to say there's going to be one. All righty. Next, I see that there is no
Next,
established
we can
specific
do
parenting
the
time,
three of
correct?
No.
Correct. Yeah.
Okay, and that's what you're asking for.
Yes.
Okay. Well, either party may ask for specific parenting time at any time in the case when none has been issued. So motion's granted. I'm going to send you to the front of the court. Reason being, I don't know your work schedules. I don't know anything about you, nor about anything about the child. So I can order something draconian right now and maybe interfere with your lives and make it worse. That's why I will not order something in 5 minutes on a Friday morning when the case has been going on for over 2 years, and I have no idea what you guys have set up and been doing. Because your
Right,
motion is
okay.
pretty blank. All your motion says is you're asking for parenting time, and there is no established parenting time, and there isn't by
Yeah.
court order. So I'm like, there's nothing here. I don't know anything about it. So I will send it to the front of the court. Your fees have been waived since you applied for the fee waiver due to your incomes. So I'll send it to the
Yep.
front of the court. They will be contacting you shortly. Okay. Please have your schedules available, the child's schedule, so that we know when each of you is available. All right.
Okay.
And that way a specific parenting time setup can be done. If the two of you can work it out, that's great. The front of the court can also assist you in, getting it together so that both of you understand. Normally the only time we have to, how old's the child?
She'll be 7 Friday.
She'll be 7, so she starts school. So she's not available during the days. So basically evenings and weekends are pretty much all we have to work with, and summers and holidays. So we try and divide those out as best as possible, including giving a weekday or so. That way each of you, when the child gets a certain age, you can both be taxi services to the child. That starts about age 12. So
Yeah.
okay. So, but yeah, we try to give you each enough time to establish a good rapport with the child and take care of the child. Just remember, when you have parenting time, it's time to be a parent. It's not time for possession. In other words,
Right.
she's still a child. She still gets, if she has school events, you got to get her to them. You got to get, allow friends to visit, all of that. Again, it's not possession, folks. So, all right. Front of the court will be contacting you shortly with the fees waived.
All right. Thank you.
All right. Take care of yourselves.
Yep,
Yes,
you
sir.
too.
Well.
Not connecting. I don't think we've had this many connection problems in a while.
Yeah, it's been a while. And I kept messaging him. He wasn't answering me.
Yeah, well, he's on his phone,
Identifies
unfortunately.
himself. So I don't think the reason I say that is I don't think he's going to see my message to connect to audio.
Right. This is your motion, Miss Sinclair. It seems reasonable, but I'd need to hear from Mr. Sinclair. What was your thoughts on that, Mr. Sinclair? It gets you out of the arrearage. Some of it.
Yep. I just continuing to find employment, and it would get me out of the arrears. Yes.
Okay, well, it gets you out of all the arrears that are currently owed. By the way, any arrears over 2 months under federal law dings your credit rating. So there is a huge benefit to you. So, because this is, what's the job prospects looking like?
Heating and cooling position over in Detroit.
Okay. So you do HVAC?
Yes.
Cool. All righty. My question would be, do we want to do this piecemeal, and we'll, because I mean, you can do this every time it comes around, or you guys could go to the front of the court and agree to it. So, but what I can do at this point in time is basically waive your arrearage. I believe we've got a sum total here of 8,977.
Yes.
As of September 1st.
Yep.
Okay, so his arrearage will be waived, and your amount you owe of the 90,502 would be reduced by the 8,000. Correct? Okay, I will go ahead and grant that to both of you by your agreement. And I'll issue an order that zeroes out his arrearages as of September 1st. or as of August 31st, and then September 1st it'll go on, and then I'll reduce what you owe him from the mortgage from 90,000 down to about 81,000 or whatever.
Okay. Thank you.
And again, if you need to, you guys can go to the Legal Assistance Center on the 5th floor if this continues, and you can keep piecemealing it and doing the same. You can copy the order that I'm going to send out and just change the numbers. Okay.
Okay.
Mr. Sinclair, I'm sorry you had to go down to the courthouse. Somehow you missed the memo. We've been trying to keep a lot of the motions on Friday mornings to Zoom so that it's easier for everybody. But in any event, take care of yourselves. I'll grant the motion. Have a good morning, everybody. Good luck on your job hunt, sir.
Thank you.
Thank you.
Man, I think HVAC would be just chomping at the bit for more of you.
Oh, yeah, you'd think.
The unfortunate part about this one is I don't have the file.
Huh.
Yeah, that was the one motion we didn't get the file for.
Oh, okay.
And it is a 2022 case, so I don't know why
Judge
we
must have it for something then.
something must, because yeah, it's a closed case. So in any event, watch it show up on Monday morning. It'll be there on Tuesday morning when we get there.
You know that's how that's gonna work.
Oh yeah. So okay, who's next?
Moto G Stylist, can you identify
What has led to
yourself,
this?
please?
I mean, you declined DNA testing in 2016.
At that time, I didn't decline it. I didn't get.
Yeah, you did.
paperwork.
No, if you filed an answer.
Yeah, I probably didn't read it right, Your Honor.
Well, your answer says I'm the father of Kennedy. Something DW Fresh Market.
Yeah, that's where I was working at
Yeah.
DW. Yeah, I'm the father of both of them.
You're the father of both of them?
Yeah, I'm for Kennedy and Orion with the same woman. I'm just getting a genetic testing so I could get on the birth certificate. My mother have my son right now. She got full custody of him now.
Actually, this order makes you the father. You should be able to get on the birth certificate.
That's why when I went down there to try to get a birth certificate, they told me I had to, go through this right now.
Okay, well, hold on. I'm trying to figure something out here because I think I only have one child on this case. What is the second case? This is the 2016 case. What other case do you have?
I got one with Orion.
All right, because this case that you filed in only has one child. So you threw me when you brought up a second one. So there must be a second case that this one was. When was the second child born?
The second child was born January 4th, 2016.
And Kennedy was born in 2013.
Yeah, 2013.
When did you say that the other child was born?
Orion, he was born January 4th, 2016, 17.
Holy mackerel, how did that get missed? Because this case was filed in March, but it only brings in Kennedy. It doesn't even mention the other child.
Yeah, the other child, he just got, my mother just got sole custody of him.
I take it there's a guardianship?
Yep, correct.
And you say that there's a court case for that other child?
Well, I thought it would be on this right here. That I got both of their names on there.
No, but only one name is on here, and that's Kennedy.
I would like to get both of them. If
Yeah,
possible.
well, we may have to work on that.
Okay.
Yeah, I'm trying to hunt through the file to see if they ever. Miss LeVay, can you check court view and see if there's a secondary case? Yeah, there's a copy of the from April of 2022 on Kennedy for the guardianship. There's a copy of that order in this case, but no other child is mentioned.
I don't understand. I know her mother was trying to take my rights from Kennedy. That's why I had to do that to try to not let her get full custody of my
Okay,
son.
so this really isn't about DNA testing. This is about ensuring that you get your name and become the correct legal father. What's the other child's name again? Miss LeVay, did you have any luck? Is there any other cases?
Okay, when I put in Eric King, I get like 100 cases pulling up. So is there another name I could use to?
Well, Devonna Belzer.
Devon. Okay,
So put in Devonna Belzer.
that's better.
Fewer cases?
Yeah.
No offense, Mr. King, but you have a common name.
Yeah, I know, I do.
There's a 2021 guardianship case with Judge Rossi. There's, oh wait.
There should be a case between 2016 and 2018 other than this one.
Are you looking for a guardianship case? Is that what?
No, I'm looking for a paternity case.
Okay. There's a 2021 DP case, dismissal for non-service.
Oh, God.
It was dismissed on June 9 of 2021.
All right. Mr. King, what we're going to do is I'm going to bring you in for a settlement conference in a couple weeks, and I'm going to invite Miss Belser as well so that I can discuss this with both of you and see how to proceed, because Michael may not have a legal father right now.
Right. That's what
and if that's the case, I'm probably going to tell both of you to notify the prosecutor, who can restart that 21 case and get that child a legal father. Okay.
Yeah.
Or the two of you will discuss maybe signing an affidavit of parentage, which makes you the legal father.
Okay, but see, with Narayan, my mother got custody of him. They gave my mother full custody of him.
I understand custody is one thing, but who are the parents? Because she's listed as the mother. You're listed as the father for Kennedy. You're not listed as the father for Michael.
Right.
Michael at this point in time does not have a legal father. So we'll see if the prosecutor may be able to help you, but we'll have a settlement conference and see if we can do something on that child's behalf.
Okay.
So we'll bring you in about 2 or 3 weeks. I'll have, like I said, I'll invite both of you. If the court invites Miss Belser, maybe she'll show up. Okay. All righty. That way we can discuss what to do. And realize third parties may have custody of these kids, but let's see if we can get them their correct parents. All right.
Okay. Thank you.
And
Thank you, Anna.
yeah, and we'll try and pull up that Miss LeVay, if you could order that 2021 case so that I can make sure that was a Michael case.
Sure thing.
All righty. That way I can find out why the ball was dropped. All righty. Take care, Mr. King. Good luck.
All right. Thank you, Anna. Bye-bye.
See you soon.
See you soon.
All righty.
Yeah, that case was a Judge Hillary case.
Odd. Should have been a Judge Semitis case.
It's Hillary.
Hey, with 14 to 15,000 cases coming in a year, it's amazing.
Yeah.
Amazing that more don't fall through cracks. Seems like we've had a lot going on over the past 4 years.
Yes.
So the two of you had a support case that was entered in 2019. There was a front of the court recommendation that came out soon thereafter, but was never entered. And then, sir, you were incarcerated from when to when?
June, like June the 3rd or something like that, until the beginning of March 2020.
2020. So you were incarcerated for a while there, which explains why the child support order would have been inappropriate. Miss Winters, you indicate that you guys got back together. When was that?
When he was released from jail.
So you were together from 2020 to 2023, correct?
We were together from 2012 to 2023.
Okay. Well, I mean, despite the incarceration and okay. Yeah. All right. I'm just trying to piece this together because there's a couple of avenues, but obviously this is a motion for child support and that is appropriate. So we are going to get that reviewed. I can't enter the order that was issued 5 years ago because of the intervening events of you guys living together and his incarceration. You know, if it weren't for those things, I might have gone back and entered this order from 5 years ago. But because of the intervening events, it's inappropriate. Yes, Mr. Hines.
Oh, no, I was just, during me being incarcerated, I was on work release. So I still was providing for him and buying cars.
In any event, the two of you got together, you stayed together, and so child support was inappropriate while you were living together. Now we have to figure out, because essentially the issue is somewhat reserved. Not really, because normally I can't order child support until from the date of notice on this one. So I will send it to the issue of child support. This time it should enter if nobody objects. Okay, it's not going to be one of those you have to bring a motion. I think they made it so that you had to bring a motion back then because of the incarceration. So they weren't sure the order was appropriate. But what I'm going to do now is we'll start this on August 1st of 2024, and I'll send it for child support review. Please have your most current pay stubs available to the FOC. Okay. Any questions?
Okay. No, you said have them available, meaning I need to bring them?
Yeah, you'll each need to bring your pay stubs. Child support is set by law. They plug in your income, her income, and out spits a number.
When would that take place?
It should take place in maybe 3 weeks or so, 3 or 4 weeks, because
So we
child
would
support.
get a
Yeah,
notification.
you're going to be getting a notification from the front of the court. Make sure your addresses are up to date at the front of the court. So if these are the most current addresses on this motion, that's who they'll be sending them to. All right. They'll be notifying you. They'll send you a packet to fill out, including requesting current pay information. All right.
All right. And I got a question. So as far as like with me, like with me having like a car in my name for her and paying the car insurance, since you set it back to August 1st,
yeah,
and when she put the motion in after I had been paying her for it,
well,
I know you did current,
I know. I know. But child support is for the child. It has nothing to do with the relationship between the two of you. I don't know what you guys are doing.
So that means that for that point, do I have to go through like
I can't order you to do anything with property. This is a support case. Now, it's not even a divorce case, so I don't have anything to do with property in this case. I have no jurisdiction over your property.
Right. You say you just date the child support starting
August 1st. Yes.
So I owe for August, whatever.
You'll owe for whatever you figure out, it'll begin on August 1st.
Okay.
Okay. All righty. And the two of you have some wiggle room on what you can agree to too. If there's things that you know that you're doing that the court wouldn't authorize, the court may take some of that into account, but we'll see. That'll be up to the two of you. All right. Have a good morning. We'll get this to the front of the court. Take care, everybody.
Thanks. Bye.
All righty. Ms. Crier, did you connect? All right. Sorry, we kept you on because you hadn't connected yet. So
sorry about that.
No, relax. It's okay. I didn't want to put you in the waiting room and then still not connect and then have you show up. Yeah. Sorry for the delay, but the other side never showed. So we always give them a chance to show. And when we have only one side, we just keep waiting until we've gotten all the match sets together. So we're going to go on the record in the matter of Crier versus Welch is what's on the file, but okay, it used to be Arnold. All right. Yes. So this is a motion for child support. It is appropriate. So I will send it to the front of the court for review. It'll begin on August 1st.
Okay, thank you.
Thank you. Yeah, it was an easy one.
I see.
even if he didn't show up, it was an easy one. So even if he showed up, it would have been an easy one. So it's obvious it hasn't been reviewed in 4 years. You may ask for a review every 3 years.
Okay, so does this mean that he will be paying?
Oh yeah. Well, I don't know. We'll see what it comes out.
Okay.
I don't know what his income is or anything. If he could be on state aid and we can't touch that, he could be on SSI. We can't touch that.
Oh, he's a fireman.
Oh, okay. Well, in that case, he gets a W-2. So yeah, there should be. They'll need your income and his income. They plug in both and out spits it.
I'm not working.
Okay. Well, they probably might hold you to a job if you don't have any mental or physical disabilities that would prevent you from working.
Okay. Yes, I'm looking.
Okay.
But stay at home mommy for right now.
Yeah. Yep. So I'll send it for a child support review. Start on August 1st. Okay.
Okay. Thank you, sir.
Have a good morning. Take care.
You as well. Bye-bye.
Bye. Okay. Next.
Okay, we can do.
Oh, good grief.
Already? We just got here.
Well, I don't know when you're here or not.
We just got here and you're already saying good grief.
Yeah, well.
I know, it's Friday morning.
There are a couple I'm going to have to debrief with my clerk afterwards.
You're going to be on YouTube again.
Oh, God, help me no. People can't be that bored.
I think they are. Although I have to say, Kendra Ortega writes down all of the case law that she hears. And
smart.
Yes, and when something good comes up, she reports it back to me. Which is awesome.
Yeah, we tend to get thrown a lot of cases. So, all righty, Mr. Vance, did you connect?
He's here.
Yes, sir.
No, I'm asking him if he connected. I need to know if I have a two-way connection. I'm going to ask Ms. Barnes the same thing. Ms. Barnes, did you connect? You need to unmute.
Yes, I did.
All right, you guys have, we're going to be in the matter of Vance versus Barnes, case number 19. You guys have thrown a grenade into this one. I wish you guys would have shown up about 5 months ago, which would have been the smarter move.
Agreed.
Because we have a school issue now, and the two of you have week on, week off parenting time, and you live over 100 miles apart.
104 miles, exactly.
Oh, okay.
I did it.
Did you want to get the 0.2 in there too, or something?
I did.
Oh, all right. But in any event, you two live far enough apart. Week on, week off is a joint custody environment that's been going on for 4 years. So the established custodial environment is with both of you. At this point in time, something's going to have to happen to wrench that away. For now, the court has no authority to grant a school because I have to have a hearing first. So we're going to schedule you for a hearing, and that hearing will obviously include custody, parenting time, and child support, because something's going to have to change. Because obviously, no matter what's the best worst case scenario is I could have the child go to school in Pawpaw, midway between your two houses. But that's not going to be good for the child. Let's face it, driving in the winter in January and February, 100 miles north and south on 131 is not exactly the safest place. But I can't undo on a Friday morning what you guys have set up for over 4 years. So we're going to grant you a hearing. Because of the circumstances, I will discuss with Judge whether she'll do the hearing or she wants me to do it, because she may not want the 21-day appeal period on this.
Judge, I have a question. Could you
Sure.
send it to the friend of the court for a quick assessment? I
They,
think that.
they don't have a quick assessment.
Okay.
It's going to take 3 months.
Okay.
And
Well,
they will not assess school. They will
Not so
only-
much the school, because we know we're going to be changing the established custodial environment.
But they don't have a change of established custodial environment without the school being determined.
I know.
It's all mixed.
I know.
Change of circumstance is the school placement. And who knows? Maybe somebody does come up with something creative and the kid goes to somewhere midway and we keep the week on, week off. That is a possibility. It's not a great option.
The
Not
parties
one.
in South Haven at this point is not a great option, but it's an option.
Like I said, there may be some middle point school. We've done that before when the parties live closer and they keep their week on, week off. But you guys live so far apart, I'm not sure that's in the best interest of the child. So this is all combined.
Agreed.
Ms. Barnes, you're sitting there pretty quiet. Any questions? I think you at this point we have done this in the past. The child can be enrolled in both kindergartens. Kindergarten in his area on his week and your week on your kindergarten.
Things that she will continue to miss out on, and just
Yes. And again, had this been brought 5 months ago, maybe we would have been able to do something right now, but I can't. I wish. These always break my heart because I can't do what you're asking me to do on a Friday morning. The school issue has to be vetted out at a hearing, and once the school issue is vetted out, then a custody issue, and it'll be kind of like a combined issue to figure out what's going to happen. You know, sometimes what happens too is somebody gets the school year and the other person gets like 3 out of 4 weekends and the entire summer. And you maintain the joint, it's just not perfect. There are many options here.
That is an interesting option because they're not that far apart that we can't do that. So that's an option.
It is an option, and that's why I throw it out there so that you guys can enter into discussions. Ms. Barnes, I would please see if you can at least get advice from an attorney, okay? Because at a hearing, you will be treated like an attorney. So you'll be given an opening statement. You'll be required to present witnesses. I'm not even sure who has the burden here because you're both on equal footing. At this point, Ms. Quist, I would let the burden begin with you because that way Ms. Barnes can see how it runs. She would present her witnesses. You'll be able to cross-examine them, Ms. Barnes. And then once she rests on all of her witnesses, then you may call yours. And that includes we're going to have information about the schools that are proposed, what's going on, you know, what their school ratings are. But like I said, there are a lot of odd things that happen in cases like this. And I've thrown out 2 of the weirdest ones, but you never know. And it may be that somebody, you know, because there's no perfect answer here. The last one I did, one lived in Lansing and one lived in Grand Rapids. And the one party had custody. Well, the school issue was settled on the oldest child, but the middle child did what you're doing with yours, week on, week off. Then it came down to the youngest, and we did. They had to go to kindergarten in Lansing and kindergarten in one of the schools here in Grand Rapids. And then once we made the determination, it came out that both kids would go to the same school in Grand Rapids. And it was just what it was. That was in the best interest of the child, of both children. So, although the fun one of that one was the older child had a boyfriend in Lansing when she went to school in Grand Rapids, and she wanted to go to Lansing. And I'm like, you're 12. I'm not letting you move because of a boyfriend. Not when when all the other facts are there. So I'm spilling this, Miss Barnes, so that you get an idea of what you're facing. And there can be many different outcomes. All right. There's no clear-cut outcome. But again, I will talk with the judge about her doing this hearing so there's not a 21 days, that everybody's prepared so that maybe we get this child into one single school by the end of the semester.
Thanks,
Because
Judge.
most of us are scheduled out 90 days.
Yeah, I was just going to say, I think we are. I am too.
Yeah, so I wish I could wave a magic wand. They didn't give me that with the black chair that I sit in. They just gave me the black chair, pointed to it, patted me on the head, and said, "Good luck." Take care. Any more questions, Ms. Barnes? Mr. Vance, you'll have your questions answered by your attorney.
No.
Yes, sir.
Okay, good luck. Well, take care of the child and good luck. And I guess she's going to have some fun. A lot of friends.
I was going to say she's got 2 kindergartens, so
Yeah.
I think you'll have fun.
A lot of friends. So, alrighty, take care, everybody.
Thanks,
And
Judge.
luckily, it's kindergarten and not grade school because I don't have that option with grade school. So, alrighty, take care, everybody.
Thanks, Judge.
Okay. 62DS. I've read the motion. I've also confirmed that there is no state aid and no arrearage is owed in the matter. So your motion is granted.
Wonderful. Thank you.
Yeah, the only thing you missed was you should have given me a copy of an order to sign. So now I've got to hunt down an order for you. I'll do that because it'll be quicker than you trying to get me one. Okay.
Oh, okay.
You sign the advice of rights. Normally attached with the advice of rights comes a printed order that I sign, and that does what you ask. So
Okay.
I'll try and get that processed next Tuesday since we're off on Monday and get it to the front of the court. It takes them 2 or 3 weeks to process the entire thing. All right.
Okay.
Any questions?
Thank you so much.
Any questions?
Is there any more paperwork that I should do on my end?
Nope. You guys did everything you needed to do. As long as there's no state aid, and if state aid ever gets involved, they take it back to the front of the court. Just to let you know.
Okay.
That's in the advice of rights that everybody reads but doesn't understand.
Okay.
Mr. Matunda, is there anything you have to add?
Nope, that's it.
Okay. Thank you.
Thank you.
Have a good morning, everybody.
Thank you. You too.
What the hell?
Right.
We had to be on the record when I said that. Great. Okay, thanks. In any event, we are here in the matter of Wallace versus Wallace, case number 2. Mr. Sherlin, this is your motion. I will note that Mr. Wallace is not present. This matter was set by the court at 9:30, and he has not shown up and not been in the waiting room. But I guess I should confirm he is in New York currently.
I know that, Your Honor. My client did have contact with him on the 19th, where she did some supervised parenting time, and that's when he was served personally.
Right.
So he was present in the area at that point. My client reports he had with him a girlfriend and, on the 22nd, I'm sorry, I said the 19th, I meant the 22nd.
Okay.
Oh, I'm sorry, 19th and the 22nd.
Give it up. You're not good with dates, dude.
But he did.
In any event, he physically had it, and he had it over 7 days ago.
Yeah.
Great. Not only that, he knew about it, but I read your motion, and I guess he moved to New York at one point, then came back, and then went back to New York. So we don't know if he's doing that for vacations, for some kind of other purpose, or to find work.
I have no idea, Your Honor. In fact, my client right now, even if he's in the area, she doesn't know where he's living.
Okay. All right. So basically, this is going to be a pretty simple motion. I'm going to grant temporary legal and physical custody to your client. Parenting time reasonable as agreed, and that can include supervision as necessary, determined by the plaintiff. Or do you want me to send it to the Y?
So would you prefer to agree to supervision, whether it's you or someone else, or would you rather have it done at an agency?
I think for Giovanni, I think it would be best for it to be more natural.
Okay. Yeah, that's kind of why we offer the option, because you're right. Going to the Y in a room that has double observation windows and is more sterile, it's necessary, but if we can avoid it, that's great. But we're going to give you control over that at this point since he's not here. And from what I read of the motion, he's been pretty erratic and he's not been of much help or seen the child, except under your supervision. I mean, you separated when? April?
April, yes.
Yeah. So you guys have been separated for a while. And then I will obviously send this to the front of the court for custody, parenting time, and child support, Mr. Sherland.
Would you have a separate order of reference, Your Honor?
I'll do the separate order of reference, but you can do the custody, parenting time order. That's temporary.
What about the fee, Your Honor?
That's what I'm trying to figure out. He's not here, which means I can't have him pay. She's represented.
He is, but you know,
I was going to say, hold on, let me look, because you did give me the child support guidelines attached that you were proposing.
Yes.
Due to incomes, I will waive fees.
Thank you very much. And then
thank you for attaching that. That was what was helpful for that, because then I can actually look at the fees. Because if she was not represented, she'd probably have them waived.
And then, Your Honor, there was the issue of the repayment of, or the 670.79 that my client's asking for reimbursement related specifically to the Verizon bill, and that's an amount attributed to the defendant. And then she would like to release his phone number to him so she doesn't pay for his phone number.
I would grant that order.
I had to pay $280 his buyout for his phone. He went and got a brand new phone and started a new thing and left me.
Is there an additional $280 or is that built into the $670?
It's an additional $280.
My client reports there's an additional $280. I know it's not part of the motion, but it's subsequent to the motion. May we?
Well, and you need the order that's going to release the phone, and it won't be released until that payment's made. But she's already made it. She needs to be reimbursed, correct?
Yeah, she paid $670.79, right?
Right. Yeah, that's according, and you've got everything attached to the motion that indicates that.
And then can I add the $280 to it that she also paid?
If that's, yeah, I'll take that at this point in time. So to move this along, that he'll owe it to her, because I'm not sure we can, you know, and obviously it's reserved if he wants to argue it. Yes. You can give him make sure you give him copies of the receipts.
It sounds like we can put in there that the phone has been terminated and that we'll just add those amounts as a liability. And then can I add the mutual civil restraining order?
Yes, please.
Okay.
I don't want any assets dissipated. I don't want any more debt incurred by either party.
So I can certainly draft the order, but I'm not sure I have an address that I know where to send a 7-day notice to him.
Good question. I mean, that's why I was asking, do we have his last known address? Was he living with his mother or something?
Section 8, but
Where did he live last that you know of?
The Elger address for sure, but I know he doesn't live there.
All right. Did you know when you separated, because he was living with you up until April, do you know if he put a forwarding address on your?
No.
Are you still receiving mail in his name at the place that you currently live?
I moved with my parents.
They both moved, Your Honor.
Okay. Well, send it to the former address, send it to the elder address, and at this point in time, those are the only known addresses, so that'll be the best we can do. And if you get them back, then let's file a motion to serve notice by publication.
Okay, sounds good. We'll try that, Your Honor.
I did have the address. I was on our Amazon thing. They said he purchased a house in Rockford, and I had that address, but I don't know.
Send it to that one too.
We'll grab a bunch of addresses and send it.
I think the last one I did, I sent to 4 different addresses, and I did the order, so I drove my clerk crazy. So
we will absolutely do that, Your Honor. Thank you very much.
All right, you take care. Good luck. Just to inform the parties, this case was brought by neither of you. The state of Michigan brought this case because of state aid involved. So neither of you asked for this, neither of you wanted this, but when state aid's involved, the state mandates that child support be set by law because they're going to confiscate part of it to reimburse the state for what they pay on behalf of the child in this case. Okay, so with that being set up as the groundwork, I'm going to let Ms. Brower, who represents the state of Michigan through the Kent County Prosecutor's Office, to proceed with her motion.
Okay. Your Honor, both of the parties participated in the pre-hearing conference that took place on August 6th, 2024. The plaintiff earns $18.52 an hour at 36 hours per week. That's the income I used for her. The defendant said he earns $22.95 an hour and works 76 hours every 2 weeks. That's the income that I used for him. When I received his pay stub from him after the fact, turns out that he actually earns $22.94 an hour. So I'm just off by a penny, but FYI. I ran the guidelines with the defendant having 120 overnights per year because the party said that that's what they were working toward. So that's what I went ahead and used. The defendant did not agree with the child support recommendation. The parties have another child. in a 2019 case. So therefore, that's why I ran guidelines for 2 children, but the 2 cases will be consolidated. So I am asking that the court enter the proposed judgment as well as the UCSO.
All right, thank you. Ms. Hurd, you're the plaintiff. Any comment?
Yes. We came to we talked about this right afterwards, the first hearing. We were thinking about doing joint custody, and he get them 2 weeks, and I get them the other 2 weeks out of the month, and we do rotate holidays.
So you want to do you want to do 182 overnights a year?
Yes.
Okay. In that case, we'll run it at 182. Mr. Libet, is that your understanding?
Yes, sir.
Okay. So we'll run it at 182, Ms. Brower, and let's see what the numbers change to.
Okay, would you like me to do that right now?
If you don't mind.
Okay.
We got a couple minutes. It shouldn't take that long.
Perfect. It should not.
Then again, famous last words. I have those moments where it's like, okay, now that I've said that, hold my coffee. Because I can't have
Okay, so 182.5 overnights. Child support recommendation is for the defendant to pay a total of $53 per month. That would be $14 per month in base support for 2 children, $39 in ordinary medical for 2 children, for the total of $53 per month. And then for 1 child, it would go down to $10 a month in base support and $19 per month in ordinary medical.
Okay. If this agreement and arrangement does not work out, it's reserved to come back to look at it. All right. And the state will look at it in 2 years.
Okay.
So just be forewarned. All righty.
Okay.
And if the state finds out that you're playing games with this, there could be consequences. Just to let you know.
No games.
I know, I understand, but I just had one earlier that's exactly what they did, and they turned around, and after 8 months, he's never taken the kid once.
Wow.
And the state was a little upset. So, all righty. Well, that didn't come up. That didn't come up on the record, but that was the undercurrent. All I did was send it to the front of the court for a new. All I did was send it to the front of the court for a full child support review. So just remember that. Be careful with what you ask for and what you agree to, but I'm willing to go with your agreement because I'd prefer that you guys raise these children, not me. All right? Take care of yourselves. The state will be content at this time with your agreement.
Okay.
Okay.
So, all righty. Have a good morning.
Thank you.